Article 15 is about equality in general social life. Article 16 is its focused application to something more specific, jobs in the government. And in a country like India where government jobs mean security, status, and a stable career, Article 16 is enormously important. Article 16 Clause 1 says there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 16 Clause 2 says no citizen shall be discriminated against in respect of any employment or office under the state on grounds only of religion, race, caste, sex, descent, place of birth, or residence. Notice something. Article 16 Clause 2 has two extra grounds compared to Article 15 Clause 1. Descent and residence are added. This is directly tested in exams. Now, just as Article 15 had exceptions that permitted positive discrimination, Article 16 has clauses that allow reservations in government employment. Article 16 Clause 3 allows Parliament to prescribe residential requirements for government jobs in any state. This means Parliament can say that for certain state government jobs, only residents of that state can apply. Article 16 Clause 4 is the original reservation clause. It says nothing prevents the state from making provisions for reservation of appointments in favor of any backward class of citizens that, in the opinion of the state, is not adequately represented in the services under the state. This is the constitutional basis for OBC, SC, and ST reservation in government employment. Article 16 Clause 4A was added by the 77th Amendment of 1995. It allows reservation and promotions for scheduled castes and scheduled tribes. This was Parliament's response to the Indira Soni case, which had held that reservation cannot apply to promotions. Article 16 Clause 4B was added by the 81st Amendment of 2000. It allows carry forward of unfilled reserved vacancies from previous years. So if reserved seats in one year could not be filled due to non-availability of suitable candidates, those vacancies can be carried forward as a distinct reserve. The most important case on Article 16 is the Indira Soni versus Union of India case of 1992, popularly known as the Mundal case. This was a 9-judge bench that ruled on whether the government's implementation of the Mundal Commission's recommendation of 27% reservation for other backward classes was constitutional. The court upheld the 27% OBC reservation, but it laid down 4 crucial limitations. First, the 50% ceiling. The total reservation under Article 16 cannot exceed 50% of the posts. States cannot have 80% or 90% reservation. Second, the creamy layer exclusion. The most advanced among the other backward classes, identified by certain income and social criteria, must be excluded from reservation benefits. The idea is that the most privileged among a backward group should compete on merit and leave the reservation benefits for those truly disadvantaged within the group. Third, reservation in promotions is not permitted. This was subsequently overturned by the 77th Amendment. Fourth, there should be no reservation in posts requiring specialized skills like in technical or scientific institutions. In 2024, the Supreme Court in a 7-judge bench case held that subcategorization within the scheduled castes and scheduled tribes category is constitutionally permissible. States can give a higher quota within the SC and ST reservation to the most disadvantaged subgroups within those categories. This overruled the E.V. Chinaya case of 2004 and is one of the most significant reservation law rulings in recent years. Now your MCQ. Which of the following was established by the Indira Soni versus Union of India case of 1992 regarding reservations under Article 16? Option 1. Reservations can exceed 50% in states with exceptionally backward populations. Option 2. Total reservations cannot ordinarily exceed 50%. The creamy layer must be excluded from OBC reservations, and reservation in promotions is not constitutionally mandated. Option 3. Subcategorization within SC and ST categories is not permitted. Option 4. The Mundal Commission's recommendation of 52% reservation for OBC was upheld in full. Think carefully. The correct answer is Option 2. The Indira Soni case laid down the 50% ceiling on total reservations, required exclusion of the creamy layer from OBC benefits, and held that reservation in promotions was not constitutionally required under the original Article 16, Clause 4. Options 1 and 4 misstate the judgment. Option 3 describes the position that was later overruled by the 2024 subcategorization judgment.